So today we're talking about franchise structures.
Indeed. In particular, development agreements and master franchise agreements, because this is something that people often ask questions about because it's not clear what the difference is.
Okay, so come on then, from a legal perspective, what's the difference between development agreements, masters, etc.?
Okay, so the key thing to bear in mind that with a developer agreement, first of all, what you're doing is, as a franchisor, you are granting regular franchise agreements to a franchisee, but it's designed for them to exploit a specific area or territory. So typically, it's an agreement that says to the franchisee, you can have a first option to open, or you can have exclusivity on openings of stores in this particular area, but you have to commit to open a specific number of stores over a specific period. The franchisee may pay you a fee for those development rights up front. You may have specific terms that you want to agree with the franchisee in terms of the fee structure, but essentially it's something that sits, the development agreement sits over the top of the franchise agreement and gives the franchisee rights to a broader area than just one store at a time. That's on the development side. The difference with a master franchise agreement, although the idea is similar, you're giving a franchisee the right to open multiple outlets within a territory, but in this case, the franchisee has the right to sub-franchise to sub-franchisees. So what you would have in that arrangement is a master agreement between the franchisor and the master franchisee, and then you would have an agreed form of sub-franchise agreement where the master franchisee themselves finds the sub-franchisees. So you have a 3-tier rather than a 2-tier.
And all those tiers need to reflect the agreement above.
Yes, they do. So as a franchisor, you lose a bit of control in this process. But the upside, as you'll talk about in more detail on a further franchise bite, is going to be the reach and the speed at which you can develop into an area. Just while we're talking about it, one other thing to touch on is area representative agreements. So as an alternative to a developer agreement or a master agreement, some franchisors appoint area representatives who are responsible for finding franchisees for a specific territory. But that's different to a developer agreement or a master, because all that third party is doing is finding potential franchisees that they are introducing to the franchisor. So they're an introducer rather than actively a franchisee. The franchise agreement is always then between the franchisor and the franchisee.
Perfect. And on a development agreement, just while we're talking about those, normally they're over a number of years and people have a certain number of opening, net new numbers that they need to open, but might miss one of those targets. But you as the franchisor might see, well, they've got a strong pipeline and should be able to catch up. Is there any comment from a legal point of view on that? So I'd see that as, okay, you've missed your target by 1, but I can see there's an extra 3 that are in next year. I'm comfortable to continue as we are. But does that mean anything from a legal point of view?
As a franchisor, you're always going to want to be pragmatic about it. You have to have minimum opening numbers per year, because otherwise, if the developer underperforms, they have clogged up your market and you can't exploit it any other way. So you must reserve your position on it, but being pragmatic, if you know that there's a strong pipeline that's ahead and you still have trust, then you're going to agree to some kind of variation or a catch-up period.
Perfect. Very clear. Thank you.